What if I said no? All right, so I'm Victoria Barth. And let me say that my name before I became a Barth is Victoria Nana Amasewanyako Osei. My mother will never forgive me since she's been advocating for me to add my father's Osei. So let me put it here so everybody knows my origin. I'm a lawyer, been in practice since October 2002 when I was enrolled. I'm currently the managing partner of Samukujetu and Associates. I'm also the head of faculty for advocacy and legal ethics at the Ghana School of Law. I serve on the board of regulated financial institution as well as a non-profit organization, the SOS Children Villages Ghana, which is an organization that is focused on making sure that no child grows alone but is able to thrive with their families. I am married to Ben Gustav Barth. We are blessed with 4 daughters, the last of whom are teenagers, and so we are on our way to becoming empty nesters. Unlike many people who grew up with lawyers in their families or knew from day one that a career in law was mapped out for them, I gravitated towards the law based on my natural interest and strengths. As a child, I loved to read, and I also loved watching TV, but not just anything on TV. I liked drama that had to do with the law. And growing up, I remember there was a show called Matlock on TV. There was also a Perry Mason series, and further on there was LA Law and several legal dramas or shows that really caught my interest. I loved the way they dressed. I loved their confidence in how they would speak and apply the law to secure justice. And so I found that attractive. And my natural interest was in reading and debating. And for some reason, I was quite opinionated even as a child. I always had to argue things out. So I think that somebody must have said, oh, law will suit you. Or I just felt that that should be something interesting. And I also remember when I was in class 5, my parents being very apprehensive of the incoming JSS system, did not even wait. My batch would have been the final year. But they enrolled me at a public school on a military barracks where they had a morning and afternoon shift. So I would go to my regular primary school in the morning and then scurry away to the car park to be taken for afternoon classes. And one fateful day, I think they had games, and the school was near the Konfanochi Teaching Hospital, and there's a route that leads to the High Court. And we walked past, and court was in session. And I don't know, but I just felt like I had a destiny that one day I would enter those courtrooms. There was just a haunting, daunting sense of having something to do with that premises in future. It probably didn't register then, but it comes back to me every time I think of the fact that now I'm a lawyer. So I've followed my strengths and my interests. I studied economics, history, and literature. I did the International Baccalaureate, not the A-levels. And I got admitted into Southampton University to study economics. And I happened to be speaking to my uncle saying, you know, I really wanted the law. And she says, when you get to the campus, see if they won't change it for you. That's how I asked, and I never stepped into one economics lecture. And so the law became my path. When you are involved in the practice of law on a daily basis, you can't help but come into contact with developments and emerging trends. But apart from that, one of the advantages of working where I work is that we work in teams. You know, we're constantly sharing knowledge. So every now and then, on the daily, you will get a post either on the firm's platform or from colleagues about new authorities that have come, new decisions, and also again online, you get these updates coming through. But then the beauty of working in a team is that you also have other people who spend time dedicated to research and keeping you updated on developments. So for me, technology has helped because you have all these online platforms where you can go do specific targeted searches and find out what is happening. And then also briefings from people on my team and colleagues across. Let me say, I've handled, for me, most of the cases I do present challenges of different kinds. But the one that sticks out to me is a case I simply refer to it as Dominion, because the name of our client changed a number of times during the course of the case, but a Standard Trust Offshore and NIB. And it had to do with promissory notes that were issued and discounted on the capital markets. And when they came to maturity and the value was to be collected and there was a default, there was a guarantee which the National Investment Bank was supposed to honor. Let me just say that it was a case that we won in the High Court, in the Court of Appeal, and then lost in the Supreme Court on what I would say was a very technical application of the rules, which in my humble view departed from clear decisions of the Supreme Court on waiver of non-compliance with the rules. Some call it a patriotic decision. I am praying that I live long enough to see the day that the same Supreme Court sets aside that decision. But I find it, I choose it as one of the challenging cases, not just because of the anticlimactic result, but the events that happened even during the case. You know, there were allegations of bias against the Court of Appeal panel, which were, to say the least, unfounded and were found to be unfounded. There were days when we were clamoring for a hearing date and the Judicial Service would go on strike. You know, so many curveballs that one could not have anticipated. But it was also one of the cases that matured me as a lawyer because it tested my tenacity. You know, I left the Supreme Court that day, especially when we went on review and lost again. Torn between, you know, is this what I'm really meant to do? But then I knew that that could not be the end of the road. I knew we had given off our best. We had followed the law that we knew to be the correct position, and things just didn't work out. But it was an interesting case, research-wise, you know, conduct of trial and all that. Yes, but it's the outcome. That's a difficult question because I think there are so many moments. But one stands out. I think when I was about 2 years old at the bar, the managing partner of the firm at the time instructed me to represent a friend of his, a surveyor, who had gone onto somebody's land to do a survey exercise and found himself caught up in a contempt application that was brought against the person who commissioned him to do the work and other people that he had taken onto the land. So there I was, a junior at the bar, going up against a senior lawyer. Fortunately, I had done my thorough research and I was able to persuade the court, especially when he cited an authority that had been overtaken by one that I had found through research. And what was most gratifying was the relief of the client. You know, I think when he was going to court with me, he was wishing that it was the managing partner going with him. But after he saw the delivery and the outcome, to date, he refers clients to me. He speaks about that experience with affection, and for me as a lawyer, it was very fulfilling to see how what I had learned was playing out and positively impacting somebody's life. So that's one of the proud moments that I hold dear. My obvious answer would be what I tell my students in the advocacy lectures about the qualities of an advocate, which I believe cut across whether you're an advocate or a solicitor. And I probably will go through a few. So you may not think of hard work or industry as a skill, but the content of that means research, which one has to develop research skills to be abreast with developments in the law regarding whatever subject matter they are handling at a particular time. Language, and that takes me to communication skills. One's ability to communicate effectively determines to a large extent what information they are able to elicit out of a client who is given instructions, their appreciation of information that they receive, how they interrogate that and subject it to the rigors of what the law requires in the context that they are dealing with, and even how you are able to persuade, because as a lawyer and an advocate at that, you are in the business of persuasion, and how well you are able to communicate determines the extent to which you may persuade a trier of fact, either orally or in writing. So communication skill, very key. Then you have something like tenacity, which I alluded to earlier when I was talking about the challenging case. One needs to build stamina, both physically, mentally, emotionally, because you need to be working long hours, your attention to detail, your ability to stay the course and not give up when you encounter challenges along the way. You also have to develop your ability to exercise judgment. That comes with experience, but again, it comes, as I said, with researching, with observing and learning from circumstances that you find yourself in, because you have to be able to observe people and circumstances and predict certain outcomes. It's one of the things that informs how good you are, for instance, as a cross-examiner. You don't just form preconceptions, but you make sure that assumptions that you are making are based on knowledge and experience. There's presence. For me as an advocate, when you walk into a room, when you stand on your feet, when you open your mouth, you must command attention. That comes with preparation, that comes with putting yourself together, because when you are prepared and you've done your research, it shows in your delivery. So I could go on and on, but it's all about hard work, building your reservoir of knowledge, communicating effectively and respectfully. Let me add that, because the ethics are also very important. And as an up-and-coming lawyer, you want to make sure that you are not just brilliant, but that you are acting ethically. I started practicing in 2002. A few years down the line, we got the current civil procedure rules that we use, CI 47. So I think from the beginning of my career, the changes in the procedural rules, not everything was changed, but there was an emphasis on applying the rules to do speedy and effective justice. I saw the rules on amendments being enhanced, where now, so long as the facts that you were seeking to amend were arising substantially from earlier pleadings, one could rely on. So yes, in terms of the procedure for court practice, it was one of the changes that I saw. In recent or not so recent years, we've seen the digitalization of the court processes. Not every region, not every court, but most of our high courts now, we call them automated. Evidence that used to be taken longhand is now transcribed. And I remember being very frustrated when submissions were being transcribed, but I see the value now, especially when one has to go on appeal and you are fortunate enough to have what you said captured, verbatim almost. And so there's no dispute about whether you urged certain arguments on the court for its consideration, which were neglected even though they were germane to the subject matter in question. So that has helped. But even with that, there's still a lot of room for improvement. The system where counsel and the judge can read on their screens the evidence being adduced, but the witness cannot see what they are saying, and they have to be cut midstream when they are making a statement, and it is difficult for them to repeat themselves. They lose their train of thought. I think that that's something that is easily remedied, and we should look into it. Either we have one central screen in the room where everybody is looking, where the witness can see and keep pace with the transcriber, or we get software that can transcribe at the speed of speech. I see judges getting frustrated with transcribers and sometimes completely throwing them off course. And these are things that do not require, so much to change. So I'm talking about changes, but I'm also talking about shortcomings. I can't help it. For instance, we go to court and the judge is not sitting because they've gone for a seminar, or one reason or the other at very short notice, the case is not going to proceed. It's not difficult to have a WhatsApp platform. It's an innovation that I've seen with Land Court 5 recently, where we get daily updates from the clerks in the court about the cases on the course list for the next day, whether you need an interpreter for your witness so they can arrange one ahead of time, when your rulings or orders are ready for pickup. And this is something that can be done easily across the courts. That brings me to the e-justice system which we have in the High Court in Accra. At least I can speak to that, where processes that we file are scanned into the system. My understanding was that if I got to court, the judge would open their laptop and would have a soft copy of the process. But sometimes, notwithstanding that they are scanned, you get to the court and the judge has not seen the process. But there's been some milestone achievements made as far as applying technology to court procedure is concerned. I've also seen a lot more women coming into the profession and standing out. I remember when I was a pupil in Kumasi, there are very few female lawyers. We enjoyed being pampered and all that, but I'm very, very happy to see the tide turn. And I dare say that if we don't have more women lawyers being enrolled, at least the numbers have evened up significantly. So that's one good thing that I've also seen. It's an interesting question. I think as an ethics, legal ethics lecturer, I would take it from the position of the law, where as lawyers we have ethical duties to our profession, to our clients, to the courts, and to the public. And the fundamental position, because you asked me about balance, is that in pursuing and fighting to secure the best interests of our clients, we should never forget that our duty of candor to the court, our duty not to mislead the court, takes precedence over our duty to the client. And so it's not a question of winning at all costs. It's not a question of bending the law or the rules. It's not a question of hiding an authority that is contrary to your client's interest. And I know that whenever we discuss this rule at the law school, it causes a lot of controversial debates. But there's no gray area about that. Your duty to the court takes precedence over your duty to the client. Likewise, when you know that pushing a certain position against your opponent, would breach your duty to observe and adhere to the laws of Ghana, you can't do it. And so as a lawyer, you have a responsibility to educate your clients and to let them know the limits to which you can go in pursuing their interests fearlessly and zealously. As an advocate, there are duties that are imposed on you, and you have to know what the rules. And for me, that is the starting point. So the balance is where you are able to push your client's interest without compromising on your duty as a lawyer to the profession, to the court to the public and to the client. So one has to always be ethically minded to make sure that what they are doing for the client is within the bounds of the law. I think that lawyers are crucial and critical agents of societal change and development. And I say that because even the state, is born out of law, is governed by law, and order is maintained in every society by the enforcement of law and rules. And so you find that to legislate, you need people who have an appreciation of the law. And I believe that 70% of our parliamentarians, if I'm not mistaken, are either lawyers, aspiring lawyers, or law students. And likewise, we need lawyers who will interpret and apply the law effectively in being judges. And for us as lawyers in a common law jurisdiction, we shape development of law, because every case that we handle that sets a precedent becomes part of the developing and evolving law. And so in different, whether in academia, whether ensuring that those in media are protected, their free speech and investigative work is secured, you need lawyers at every stage in societal development to vindicate people's rights, for law reform, to ensure that there's peace and stability. You always need lawyers at every stage of development and societal changes. And so we are critical change agents. And we must continue to enhance our knowledge and also keeping in touch with the pulse of changes in our society to see how we use the law to positively impact the lives of those in our community. So I think the major issue that we're grappling with as a country where legal education is concerned is that there's excessive demand over supply. You find a lot of people wanting to become lawyers, regardless of whether they intend to actually practice as private practitioners or corporate lawyers or whatever, but there's a lot of interest in pursuing the legal profession as opposed to very limited resources. And we have a structure where the General Legal Counsel is mandated by statute to organize and set standards for legal education. And as a result, the law school, which is set up by the GLC, the General Legal Counsel, currently is the only institution that administers the professional law course. And notwithstanding setting up satellite campuses, Kumasi, Gimpa, still, if you look at the numbers of people who apply and write the entrance exams, it is only a fraction who are able to gain access. And in an ideal world, everyone who qualifies and is eligible should have access to pursue the course that they desire to, especially even the law, because we have a very poor lawyer to population ratio. I understand it's about 1 lawyer to 10,000 Ghanaian citizens. But the real challenge is the lack of resources. And so there's the argument that we need to come to a stage where it is not just universities that are accredited to run the degree course, which is the LLB, but also they should be licensed to run the professional course. That argument is very attractive for me, but I'm also cognizant of the fact that we need to have systems in place which will ensure that standards are maintained where there's this decentralization. We need to ensure that people who are recruited as lecturers in those institutions are really qualified, because at that level is a practical aspect, the procedural aspect of the theory that you learn at the degree level. And I look at the law school now and even look at how many seasoned practitioners are teaching those practical courses. Technology can be used to maybe do video lectures and all that, but I think that we really need to look at the options. You have students going to the Gambia to pay huge sums of money. They come back into our system. A number of them are awarded prizes for coming out as the best students over there, and then they come here and they do the post call and they are absorbed into the system. So yes, there's a case to be made about the fact that admit so many students, where will they work? We don't have enough spaces for pupillage and all that. But so long as the demand is there and it is a legitimate demand, we must work at finding solutions that meet the changes that society has undergone since 1960 when Act 32 was promulgated. On the first day of every first lecture for my final year law students, I asked them why they chose to study law. This is something I experienced as a law student when Mr. Okujeto and Justice Amegache retired were my lecturers. And 80% of those in the class will tell you, oh, to defend the vulnerable and the destitute and to make sure that people's rights are vindicated. In recent times, I get more honest students who tell me that it's about the money, the security that it provides, the prestige. You know, they see lawyers driving in flashy cars and living the big life, and really and truly it's about job security. But as a lawyer who, like those students, also was attracted to the law because I wanted to advocate on behalf of people who are otherwise vulnerable or challenged in speaking up for themselves, not just because they can't afford it financially. I have found over the years that pro bono work, you know, gives you a sense of fulfillment that money cannot provide, where you are able to intervene with your skills and knowledge to make a difference in someone's life who is very deserving of that difference but could otherwise not have afforded it. Currently under LI 2423, which is the legislative instrument on the etiquette and conduct rules for lawyers, it is mandatory to do some amount of pro bono work to be eligible to have your practicing license renewed. And I think that's a step in the right direction, because some of us, unless coerced, will not make room for pro bono work. For a young lawyer, even for a mature lawyer, you may find that sometimes when you take on pro bono work, it opens you up to other areas of law that do not typically fall within your area of practice. And it's an opportunity for growth and development of your appreciation of the law. Sometimes you find yourself in a law firm where opportunity will not be given to you to touch certain briefs, but the pro bono client will not be so selective about who is working on their brief, so long as they know that they are being properly supervised. So for our jurisdiction, now it is mandatory. That's one reason why it is important for you as a lawyer. 2, the sense of fulfillment that you get. 3, the fact that, you know, it creates access to justice for the wider society, which is a calling that we have as lawyers. We owe society a duty because of the privileged position that we occupy. And so it is something that improves the well-being and the welfare of the society at large, and it cannot be overemphasized, the need to do pro bono work. And let me also say that because it's pro bono does not mean that the standard of care and the duty of care to the client is lowered. No, once you take it up, you give it the same dedication, time, and attention as you would your juicy brief. This question makes me laugh because you said high profile. But I thank God that I'm getting into a phase where I'm now not going to pretend to be modest about some of these things. So I embrace the high profile lawyer. Now, how do I deal with the stress and demands of, I guess, stress and, you know, time-consuming long hours are characteristic of the work of a trial lawyer, which is what I am, and I consider myself to be, a civil trial lawyer. You have to be ready at short notice with detailed research of your briefs and questions that you have to review and come up with. You think on your feet, and it takes a lot of preparation to be able to think on your feet. So my coping mechanism, I think the first thing is that I have a passion for what I do, and so even the stress of it, I welcome it. Because if anyone knows me well, they know that I'm a last minute person. It's a weakness and it's also a strength. I tend to work on adrenaline. But these days I'm pacing myself. The older you get, or even the younger you are, you have to take better care of your health. That means making time to rest, sharing the load. So delegation, they are equally capable people that you are working with. People who can help you do some of the rudimentary stuff, because the longer you do something, you spend less time doing it and your experience comes to bear. So for me, I'm not one to exercise, but I try to walk around a lot. I climb the stairs at the court. I always say that's my gym. I don't go to bed too early, but somehow I think everybody and their metabolism, right? I thrive on the stress. I try to rest, I try to share the load. But one thing that centers me is my faith in God. And I start every day talking to God, asking for Him to give me strength and calm. And it makes a whole world of difference for me. In fact, if you're a judge and I stand before you, know that I have not come in my own strength. I have meditated on you. I have spoken to God about you. And so I calm myself down in a lot of situations because I know I'm not going in my own power. There's a higher power at work, and it strengthens me. But when I can afford it, I would take a holiday. But the people who also invigorate me are my family. Spending time with them, spending time with my colleagues, just doing things outside of the law, that really motivates and energizes me to start another day going strong, regardless of the drudgery of the work sometimes. The $1,000,000 question. Yes and no. By having it all, if you are talking about work-life balance and pursuing all your aspirations, I consider myself, by the grace of God, to be a woman who has it all, but I am not perfect at it all. So I'm married, by the grace of God. I'm blessed with 4 daughters who I hope I'm setting a good example for in terms of what they can achieve with their lives. As a wife, I prioritize being there for my husband emotionally, mentally, physically. But I've also come to appreciate that things like cooking are a life skill, not only fashioned out for women. That doesn't mean that it's not important that my family will eat and eat well. But I thank God that I'm married to a man who appreciates my career trajectory, who appreciates that I cannot be in the kitchen every day of the week, putting on the dining table food that my own hands have cooked every time, if I'm also to make time to excel at my profession and other things that I find joy in doing. So yes, when it's legal vacation, the family will enjoy more meals cooked by mommy's loving hands. But during the course of the legal year and at the height of demanding cases and lecturing at the law school and sitting on boards of organizations, by the grace of God, one can afford the services of a chef or ordering food from a caterer. And I say this unashamedly. I mean, it used to be a crime to go out with your family to the restaurants, sometimes past, depending on where you find yourself in this country. But I've watched other women leaders who have liberated me from the trap of deceiving yourself and thinking that you can do it or you will die being superwoman. Yes, you either compromise your health or your peace of mind. People will enjoy the food. You will have no appetite. You will be pulling your hair out. You know, I mean, there was a time I was a driver, I was a cook, I was a laundry woman. But when you can afford a washing machine, you buy one. When you can afford to pay a washwoman or a washman, you create jobs for the unemployed so that they can also take some of this load off you. And then really prioritize what is important. So if I'm not the one packing food for my children, can I at least ensure that a competent person is doing it, that what is being packed is nutritious, that what is being packed has been properly done? Can I, when I have the time, do it? Sure. So these days, I think that I've come to a place where I'm living not to please others or what their standards are, and I'm not pretentious about what I can and cannot accommodate, and I'm fortunate to have an understanding partner. I mean, Mr. Barth likes to see his name making the waves. He also prides himself on being married to a career woman. There are days he'll tell me he misses my tilapia soup because I used to do it when we were courting. But the dynamics have changed. So tilapia soup will come, bigger vacation, Christmas, Easter, you know. But we're not perfect, and I'm not trying to be. So many. I mean, there are social justice issues. If you look at domestic violence and environmental galamsey, so many things I could talk about. But because I call myself a trial lawyer, I'm taking one that is closer home. One that I think is a low-hanging fruit, and that has to do with access to justice. When I talk about access to justice, I'm not talking about the fact that we have the courts infrastructure, the fact that one can walk into a lawyer's office and engage their services, the fact that one knows about their legal rights and where to go to vindicate. But I'm talking about the effective administration of justice, where there's predictability of outcome, where one has an assurance that over a certain predictable time frame, they will have a resolution of their dispute, where one can tell that the people in charge of deciding their fate as far as their disputes are concerned are being monitored for their performance. So why should I have a contempt ruling outstanding for 2 years? I go adjourned, you know, and assuming it involves parties traveling from Accra to Nsawam, for instance, that's a cost to the client, a cost to the lawyer in terms of the risk of traveling to and fro for an abortive proceeding. That makes me ask the question, who is monitoring the judge? Who is checking to see that a ruling has been outstanding for 2 years when the rules say that within 6 weeks a judgment must be delivered? When I go into the court and I have done my part and I have filed my submissions and I have furnished the court with everything that should enable it to make a decision, why am I kept waiting? Is anybody checking to see that the load of this particular court is not reducing while other judges who are clearing theirs keep getting cases assigned to them? If we are not measuring performance, what is the guarantee that there's performance and that it is effective? How are we guaranteeing that the judges who work hard are not demoralized? So I'm talking about access to justice from the perspective of I have filed my process, I have afforded a lawyer, I have come before the court, and I'm assured that within 6 months, a simple application will be determined. Within 6 months, I know whether I'm going on appeal or not. I'm not saying every case can be determined within that time frame, but it becomes very frustrating for clients and lawyers when you have a matter and, you know, I don't know if I should call it dilatory tactics, but you just don't see the light at the end of the tunnel. And I'm not blaming judges. They are fantastic judges, but there must be a proper system of monitoring that keeps both judges and lawyers on their toes. I mean, for instance, you can go to a court and the judge may decide to come in at 10 a.m. Everybody knows that that is their modus operandi. How is that possible? We are losing a full hour that that person is paid to sit. If I'm absent, I don't have the luxury of my case being stood down all the time or being adjourned at my convenience. Somebody needs to be checking that. It is a cost to the client, it is a cost to the entire nation and the judicial system. It undermines the confidence in the judicial system. So I know that a lot of interventions have been made, but when I pay for the service, I must see that I'm getting the service. And when I get the ruling, I must understand it, even when it goes against me. So now I'm talking about getting competent justice delivery. So that is an issue that is so dear to my heart, and whenever I have the opportunity to talk about it, I do. And it is not to say that nothing is being done, but it is not enough, and one needs to look at discipline when it comes to our esteemed judges. Lawyers are always the talk of disciplinary action. We know we frustrate the system as well, but I think that a competent judge and a judge in control of their court and a judge who ensures that the system works will do us a lot of good. The last one, which I must throw in, for instance, is when it becomes a lawyer's duty to serve the other party. The client pays a service charge when a process is filed. So how is it now the work of the client and the lawyer to ensure that that process? I expect the judge to exercise some coercion over the administrative staff of that court, so that they sit up and know that in this court, when a process has been served, proof of service will be on the docket. And it is one of the reasons why, if I had a voice in who becomes a judge, especially in any court where trial goes on, I'll say, if they've not been in private practice, don't take them on. If you are going to the Court of Appeal and Supreme Court, no, that's not so much of a problem for me. But the trial court, they must know the pains of a practitioner. It may not be so current, but it is still trending. Spousal rights and joint ownership of property acquired during the subsistence of marriage. That is one that even the new Land Act has codified, where now there's a presumption, clearly, unless one expressly indicates otherwise. I know that there's advocacy for the rights of cohabitees as well. But I think that the fact that the Spousal Rights Bill has been lounging in waiting for so long, some of these inroads through statutes, for example, the Land Act, excites me. So that's one emerging trend. Of course, I would also go into technological advancements that are aiding the practice of law, and AI now, and what one can use it for in terms of speeding up their delivery of legal services. Be mindful, of course, of the drawbacks where AI can give you authorities that do not exist or are inaccurate. But I see that the practice of law is going to be very interesting, in the years ahead, where it is those with the softer skills, things that you cannot easily use AI for, who will distinguish themselves. And that has to do with things like, your responsiveness and your bedside manners where clients are concerned. Those are things that put as many algorithms into AI. It cannot substitute how you listen and distill facts and communicate empathy to a client, and how you think outside the box. I mean, I know that AI is on a different level, but until AI becomes a human being, despite that emerging trend, the lawyer of today has to cultivate and strengthen their emotional intelligence and soft skills. So my advice would be, regardless of whether it's a woman or a man, because You know, the mindset that it is women who are always disadvantaged when it comes to property settlement, to a large extent is accurate because of the power imbalance and dynamics of our society, where even when women contribute to the acquisition of property, they naturally would not ensure that their names are on title deeds. You know, it is a norm to have the man's name on the documents, on the shares, even though we know that we have both contributed. But as a lawyer, if a couple is getting married, from the legal perspective, it is a decision. I mean, prenup is signed by two people. So I would advise both of them, depending on where they are starting off from. We know the law makes exceptions. For instance, gifts, that and inheritance, those sort of things, the law is very clear on them. But if you see your family dynamic, or you can tell that you may have issues along the line if you don't make a clear demarcation about what was brought into the marriage, or even how the two of you are intended to own property, it will be useful to you to have an agreement of sorts. Yes, and I'm mindful of the fact that prenuptial agreements are not binding in our jurisdiction, but there are certain, you can do it as at a purely contractual level, and I see the courts enforcing that. There's been some interesting decisions where marriage has been found not to have been legally contracted, but the court enforced the contract in relation to property that was acquired during the relationship. And I think it's all about how the contract is drafted, and it should be upheld in court, because in the same way that you can contract out of the Land Act that presumes joint ownership of property acquired during the marriage, it's the same thing that you may not call it a prenup, but it may be specific to what you seek to secure. So depending on your individual circumstances and what will be in your best interest, yes, I will advise that you do that. And now, speaking as a Christian, we stand at the altar and we say, with all my worldly goods I thee endow. So for believers, that may not be in contemplation, but also as a lawyer who handles matrimonial causes and who sees that increasingly money and property ownership are higher factors for people seeking divorce than infidelity. It gets to a point where one has to be practical and advise couples to take steps that will help them to avoid conflicts arising out of property ownership. Because not everybody is so mature in their faith that they live it out when it comes to owning property. So the dynamics will inform a lot. But if somebody walks to me as a lawyer and I'm working purely with the law, looking to help each of the parties secure their legal rights, I would definitely innovate an agreement that will help them. Certainly, you know, Ghanaian man in itself is a stereotypical description. And the typical Ghanaian man would say that behind every successful man is a woman. But I have friends. I am married to a man who is very progressive, who is the father of 4 daughters that together we are raising to aspire to become presidents and leaders. And so certainly he would be more than happy to be an example of a first gentleman, so that his daughters can see that that is something that is possible, and that in finding a life partner, they look out for men who will push them as far as they can go and not feel diminished by it. That doesn't mean that I'm oblivious of the fact that we have men in our society who have been raised, you know, to lord it over women or to feel insecure by the achievements of women around them. But we have a responsibility to let men know that we are not in a competition with them, we're in a partnership, and our success is theirs. And every man must take pride in being the first gentleman, just as women have taken pride and carried the first lady role with dignity. So speaking for my firm, my answer would be yes. But I certainly cannot speak for all female lawyers in Ghana or worldwide. And what the statistics show is that a lot of female lawyers, especially younger ones, are very vulnerable in the various workspaces where they are. But I would also not limit sexual harassment to just females, even though it is more prevalent when it is between a female and a male of a higher standing in the organization. Now, I think that one of the new provisions in LI 2423 regarding conduct and etiquette of lawyers is on sexual harassment, and it mandates partners and managers of law firms to ensure that they have systems in place to protect their staff against sexual harassment. And so now, as a manager or a leader of the firm, if you don't ensure that you have policies, that you have educated your staff, that you have a mechanism for reporting an incident of sexual harassment and acting on a report, you can be held liable, for that misconduct. And it is also a misconduct, for you as a professional, not to talk of the liabilities that you can face when you are sued for such conduct. So certainly that is a good step in the right direction, but there has to be a way of monitoring whether people are actually doing what the law requires them to do. It's also not just enough to have the policies on paper. There must be constant, education and awareness, and there must be a way of measuring their application. So one has to do surveys within their law firms and anonymously collect data to test whether people are feeling safe. And then, of course, also probably have a whistleblower mechanism where that the system is such that people cannot even trust that they can report without being victimized. So we need to look at all these things as law firms grow and develop. When I started out as a lawyer, I don't think my motivation was even to necessarily make a name. I just knew I wanted to be good at what I do. And I always say I'm an all or nothing person. Once I touch it, I must do it, and I must do it to the best of my ability and to the requisite standard. But as I have grown and matured and realized that I can make an impact, for other women coming up, for my society, because I'm in a privileged position to show a picture of what a good lawyer or an ethical lawyer looks like. I've become conscious of using my position and the platform that I have to, leave a legacy of excellence. So beyond winning my cases, I want to be remembered as a compassionate lawyer who was driven more by the desire to secure justice for her clients, whether corporates or individuals, more than the desire for money. And I don't discount the value of money. One needs to be remunerated for their services. But I want to be remembered as a formidable trial lawyer. I want to be remembered as somebody who changed the legal profession for the better for upcoming female lawyers, young lawyers, someone who improved a culture of excellence and adhering to standards, and someone who used their knowledge of the law to impact society for the better. So I get new aspirations every now and then, but one of the things also is to ensure gender equality. I'm currently an ambassador for the Institute of African Women in Law, and they are running a gender equality in law campaign. And so that has become one of the new things that I'm hoping that I can also leave a legacy for.